I'm Anna. I'm one of the current presidents of the American Constitution Society. And on behalf of ACS, the Women's Law Students Association, Law Students for Reproductive Justice, the Law and History Society, and the program in public law, thanks for coming, and thanks to all of the sponsoring groups for helping us make this event happen. Sorry. We have a really awesome panel here today to commemorate the 50th anniversary of the Supreme Court's landmark 1965 decision in Griswold v. Connecticut, which in short ruled that a law prohibiting the use of birth control was unconstitutional under a right to privacy. So in honor of that, this panel is going to do a historical comparative look at Griswold's legacy, including discussing modern-day threats to access to reproductive justice a half century after Griswold. So I'll just briefly introduce our panelists, and then we'll get started. So first we have Professor Neil Siegel, who teaches here at Duke, as you all probably know. He's the David W. Ickle Professor of Law and Professor of Political Science, co-director of the program in public law, and the director of the DC Summer Institute on Law and Policy. Professor Siegel's scholarship examines the U.S. Constitution's federal structure, constitutional principles governing claims of discrimination based on race, sex, and sexual orientation, and the relationship between constitutional politics and constitutional law. He teaches in the areas of con law, constitutional theory, Fed courts, and I'm sure other things. He has 2 degrees from Duke and clerked for Ruth Bader Ginsburg, which is awesome. We also have Kristine Kippins, who's joining us from Washington, D.C., where she works for the Center for Reproductive Rights, developing and implementing strategies to ensure protection for reproductive rights and access to reproductive health care in the U.S. by conducting legal and policy analyses and by working with coalition partners and members of Congress and the White House administration. Prior to her work with the Center, Kristine was Director of External Affairs at the American Constitution Society and has been active on several political campaigns. We also have Professor Kate Bartlett, who is the A. Kenneth Pye Professor of Law here at Duke and former Dean of the Law School. She teaches family law, employment discrimination law, gender in the law, and contracts. She's written a leading casebook on gender in the law and has won numerous awards in recognition of her scholarship, teaching, and commitment to public service in legal education. We have a 4th panelist who is actually here. She's coming. There was a parking mix-up, but she's coming. And that's why I'm so out of breath, because I was just running around trying to get people parking. But Professor Maxine Eichner, who teaches down the road at UNC Chapel Hill, teaches in the fields of sex equality, family law, legal theory, and torts. She's also practiced civil rights law and employment discrimination law for several years in Raleigh. And so without further ado, I'm going to turn it over to Professor Siegel. Enjoy.
Well, thank you, and thanks to all of the groups who made this event possible. I'm honored to be here. I'm going to talk about some work that I've been doing on contraception as a sex equality right with Riva Siegel, who teaches law at Yale Law School. Challenges to federal law requiring insurance coverage of contraception are occurring as we approach June 7th, which is the 50th anniversary of Griswold. And so I think now is a good time to reflect on the values that are secured by protecting women's access to effective and affordable contraception. In 1965, as Anna just said, the court ruled that a Connecticut law criminalizing the use of contraception violated the privacy of the marriage relationship. I think it's important to understand just how significant a decision this was. Griswold offered women the most significant constitutional protection since the 19th Amendment gave them the right to vote. Constitutional protection as important as the cases prohibiting sex discrimination that the court would decide in the next decade, perhaps even more so. Griswold is conventionally understood to have secured liberty for women, but what I want to talk about is the extent to which the contraception right also secures equality for women. It's not just a liberty or autonomy right, it is also an equality right. Now, Griswold was decided before the sex equality cases of the 1970s, and I think because of the timing of the ruling, the court did not expressly appeal to equality values in explaining the importance of constitutionally protected liberty, as it would do later in 1992 in Planned Parenthood against Casey, and again in 2003 in the seminal gay rights decision of Lawrence against Texas. Yet there were some contemporaries who appreciated that the Griswold Court was protecting the foundations of equal opportunity for women given the organization of work and family roles in American society. One of those contemporaries was Ruth Bader Ginsburg, and as Anna just said, that's awesome. Today, those who appreciate contraception's singular importance to women sometimes call attacks on contraception a war on women. And yet even now it may not be immediately clear that the contraception right is a sex equality right. For example, both men and women may use contraception, even if the forms that they use are different. Analyzing the right to contraception in a historical context, in my view, helps clarify the ways in which the right secures equality as well as liberty for women. The ban on contraception struck down in Griswold was enforced in ways that reflected and reinforced traditional gender roles. Even though the law as written applied to both sexes, the state applied the law to men and women differently. And if we recover this history, we can see how the regulation of contraception is tied to double standards in sex and parenting. Recognizing enduring differences in gender roles demonstrates why denying women control over the timing of childbearing denies them equal citizenship. And with these concerns in view, I think it becomes clear why judicial decisions and statutes, federal and state, that secure access to effective and affordable contraception vindicate both equality and liberty values. So contraception was first banned in the United States not at the time of the founding, but in the decade after the Civil War. The 1873 Federal Comstock Act was premised on the view that it was obscene to separate sex and procreation. Soon after, many states, including Connecticut, passed laws that were modeled on the Federal Comstock Act, and they criminalized contraception and abortion. Like the federal ban, Connecticut's ban drew no formal distinctions by sex. Rather, it prohibited, quote, any person from using any drug, medicinal article, or instrument for the purpose of preventing conception, end quote. Even so, people at the time understood the judgments about non-procreative sex in the federal and state laws through Victorian sexual mores that were concerned with differences in the physical and social relations of reproduction. For example, the Comstock Act was passed just a year after U.S. Supreme Court Justice Bradley in Bradwell against Illinois explained the following, quote, the Constitution of the Family Organization, which is founded in the divine ordinance as well as in the nature of things, indicates the domestic sphere as that which properly belongs to the domain and functions of womanhood, close quote. About a century later, then Professor and advocate Ruth Bader Ginsburg would wryly remark in a brief in a case called Struck against Secretary of Defense that the method of communication between the jurist and the creator is not disclosed. Doctors at the time reasoned that women who enjoyed sex while endeavoring to avoid its natural procreative consequences engaged in what the doctors called physiological sin, and they predicted that women would suffer adverse health consequences as a result. Press coverage of the Comstock Act focused on women who were prosecuted for defying the ban. These new bans on contraception, which again originate in the decade after the Civil War, they apply to all at a time when men and women were held to gender-differentiated double standards in matters of sex and parenting. Specifically, men were entitled to breach prevailing sexual norms in ways that women were not, and women were expected to assume parenting responsibilities in ways that men were not. By the 20th century, Connecticut and many other states, including Massachusetts, relaxed enforcement of the Comstock laws, but they relaxed them in ways that reflected this gender-differentiated double standard. For example, during World War I, the U.S. military concluded that providing condoms to men significantly lowered the rates of sexually transmitted diseases. And rather than telling men in the military to practice abstinence, they were supplied with condoms. Well, Connecticut, like other states, including Massachusetts, followed the federal government's lead. And in doing so, gendered assumptions about sex and about parenting shaped enforcements of Connecticut's ban, and that gave rise to sex equality concerns of several kinds that we can see in Griswold. So by the mid-20th century, it was widely understood, and there are many sources that document this, that one could buy contraceptives in drugstores in Connecticut, all the way up through and continuing after the litigation in Griswold. The state deemed the threat of venereal disease significantly concerning to make a health exception from its law banning contraception, and the exception allowed pharmacies to sell condoms under the auspices of disease prevention, as well as certain products that were labeled as for feminine hygiene that might have certain contraceptive properties, although they were not particularly effective forms of contraception. Yet, like Massachusetts, the Connecticut Supreme Court rejected a health exception to the ban that would allow doctors to prescribe contraception for women who were physically unable to tolerate pregnancy or childbirth, whose lives could be in jeopardy if they became pregnant. Instead, the Connecticut Supreme Court told such women, women with a medical need for conception, that they should simply abstain from sex. The Connecticut Supreme Court did not advise men to protect themselves from the risk of VD in this fashion. Instead, the state allowed men to buy condoms on demand in the state's drugstores while making no effort at all to ensure that the condoms were being used by men, and particularly married men, to prevent disease as opposed to conception. So Connecticut crafted a health exception for men but not for women, and this led to a second inequality in the state's enforcement of the ban. Connecticut enforced the ban so as to allow men easy access to the most effective forms of contraception for men, namely condoms, but didn't allow women access to the most effective forms of contraception for women, namely diaphragms or the pill. And at oral argument in Griswold, Justice Brennan repeatedly asked into this disparate pattern of enforcement. And so by providing health exceptions for men, but not for women, and by allowing men but not women access to the most effective forms of contraception, Connecticut enforced the ban so as to give men more control than women in separating sex and childbearing. Connecticut's disparate treatment of men and women was constitutionally significant, not in and of itself, but because it reflected and reinforced traditional gender roles in sex and parenting, and indeed because of gender differences in the physical and social relations of reproduction in the United States, both then and continuing today. Laws restricting contraception present equality questions for women, even if those restrictions on contraception are even-handedly enforced. Given the organization of education and work, restricting contraception denies education and employment opportunities to those who bear and raise children, still disproportionately women. Today, no less than at the time of Griswold, control over the timing of childbirth is indispensable if those who raise children are going to have opportunities to participate in the world of education, employment, and politics. And so the right that the court recognized in Griswold helps to secure equality as well as liberty for women. One last point, equality values anchor not only the individual's right to contraception free from governmental interference, but also the government's own authority to help individuals secure access to contraception. So if you look at the court's cases, the U.S. Supreme Court's decisions, finding compelling interest in eradicating race discrimination or in eradicating sex discrimination, they make clear that those interests encompass both concerns of the community and concerns of the individuals who are the intended beneficiaries of the law's protections. And so it is true of contraception as well. The government's compelling interest in ensuring employees access to effective and affordable contraception encompass both crucial concerns of the community in promoting public health and in ensuring facilitating women's integration in the workplace, and core concerns of the employees who are the intended beneficiaries of federal law's contraceptive coverage requirement. Interests that sound in bodily integrity, personal autonomy, and as I have suggested today, equal citizenship. Thank you.
Good afternoon, everyone. Thank you so much for inviting me to speak with you all today. So let's talk about the legacy of Griswold and what is happening now. Prior to Griswold, states could make access to and usage of contraception illegal. But fast forward 50 years, and there are ads for various forms of contraception on the television. It is no longer taboo. People talk about it freely and without shame. A young woman actually live tweeted her experience of having an IUD inserted, and it was widely reported. Contraception is now encouraged and seen as the responsible thing to do. It is no longer just for married people. It's available in some high schools. And it's not like cigarettes or alcohol where you need to provide proof of a legal age in order to purchase it. It is no longer used just to prevent pregnancy. People use it to prevent cancer, to regulate or eliminate their menstrual cycle, and to treat polycystic ovarian syndrome. You can walk into a drugstore and purchase contraceptives over the counter. With insurance and a prescription, you can now get contraception at no additional cost, thanks to Obamacare, a change that has saved American women $483 million in the first year alone. By giving women the ability to time and space their pregnancies, contraception use allows them to further their education, participate fully in the workforce, protect their health, and provide a good start for their children. And that in turn helps provide long-term economic security for women and their families. So the benefits are extremely real and tangible. Over the course of the 50 years since Griswold, our perception of contraception, our uses of it, our methods of it, and our access to it have changed greatly. However, although to all of us here who have health insurance or access to a student health center that might subsidize care, that access to contraception is no longer a problem, is actually not the case. And issues of access fall disproportionately hard on women of color and poor women. Women of color face two high barriers to accessing contraception: coverage and cost. Lack of insurance coverage means that women of color are often unable to access contraception. Remember that Obamacare brought about more affordable coverage. It did not bring about universal coverage. While the uninsured rate continues to drop while the ACA is the law of the land, people of color still continue to be the demographic with the highest uninsured rates. Women of color only represent 36.3% of the U.S. female population, but they account for 53.2% of uninsured women. 38% of Hispanic women are uninsured, a quarter of African American women are uninsured, and a quarter of Asian American women are uninsured. In addition, lack of financial resources is a major barrier for these uninsured and underinsured women and can lead to their being unable to consistently access contraception or being able to access their preferred method of contraception. Women comprise 2/3 of minimum wage workers and are more likely to head single-parent households, 41% of which lived in poverty in 2012. Women are disproportionately burdened with the cost of contraception care, spending 68% more on out-of-pocket health costs than men, in part because of birth control. Women want greater access to birth control, but they often can't afford it. In a recent survey, 51% of African American women ages 13 to 34 said they had trouble purchasing birth control and using it consistently because of cost, which is just about on par with the national average of 50% of women. Cost is a major barrier to more effective methods. Cheaper methods require greater consistency, which then has a greater chance of being used improperly. IUDs are 45 times more effective than the pill, but they are staggeringly more expensive. Black and Hispanic women are less likely to use the more effective contraception methods than white women, 58% and 64% respectively, compared with 70%. And a third of all women would switch methods if cost wasn't a factor. Tying these two problems together, lack of funds and lack of insurance, the ACA's expansion of Medicaid has helped lower-income women afford health insurance, the majority of which are women of color. But there are several states who have refused these additional Medicaid dollars, and millions of poor women and their families are suffering as a result. One of the states that is refusing to bring health care to among its poorest is Texas. From a healthcare perspective, the landscape in Texas is pretty abysmal. It has the highest uninsured population in the country, and the majority of the uninsured are Latinos. Wide disparities exist in the health insurance coverage and access to healthcare within the state. The uninsured rate of women of reproductive age in Texas, 35%, dwarfs the national average of 22%, and it is much greater than in other states with large immigrant populations, such as New Mexico and California. Not surprisingly, this translates to poor reproductive health outcomes for Latinas, including, as it relates to access to contraception, high rates of unintended pregnancies and teen pregnancy. And yet, in 2011, the state of Texas enacted major policy changes to the state's family planning program. The legislature decided to cut family planning funding by 2/3 and authorize a regulation known as the affiliate rule that barred all Planned Parenthood health centers, the largest source of preventative reproductive health services in the state, from receiving state family planning funds because of their brand affiliation with facilities that provide abortion. Following these changes, the state lost its Title X grant, denying the state $32.2 million in federal funding to support family planning clinics. As a result, after many closures, family planning clinics are now serving 1/3 the population they did prior to the changes. The following year, in 2012, working with the National Latina Institute for Reproductive Health, my organization, the Center for Reproductive Rights, conducted a fact-finding mission in the lower Rio Grande Valley of Texas in order to gauge the impact of these changes, these policy changes had in Latinas in the valley. We chose to focus on the lower Rio Grande Valley because of their Latino and immigrant populations, the mix of rural, suburban, and urban communities, and the high number of medically underserved residents. We found that, unsurprisingly, for women who are low income and lack insurance, cost is a major barrier to access to contraception. Without subsidized rates, a monthly supply of birth control pills can start at $40. The cost of long-acting reversible contraceptives, the preferred method of many low-income women who struggle to access clinics on a regular basis, is generally far higher. Many of the women we interviewed explained that the high cost forced them to choose between paying for contraception and feeding their families. And if you'd allow me, I'd like to read you a testimonial from one of the nearly 200 women we interviewed for the report. Ida from Dona described her situation as desperate because her supply of contraception was about to run out in 1 week's time. She was given a year's supply from a Planned Parenthood health center before it closed. But once her current supplies ran out, she knew she would not be able to afford more. Ida supports her 2 children on her own. Quote, "Right now, I'm not prepared for another child. My financial situation is rough, pretty rough. I don't know how to get more pills because they charge for them now. They have no funds for that. No one does." Close quote. Ida also has human papillomavirus, HPV, a risk factor for cervical cancer, and has had surgery to remove cervical cysts in the past. Now she cannot afford to get a Pap test that doctors told her she needs every 6 months in order to check her condition. Quote, "It's $60 for a checkup. I thought I either pay $60 or I buy food for my children. Sometimes I don't have money for milk, food, other things. Either I pay the rent and give my children a place to live, or I have a mammogram, a Pap test, or contraceptives. It's one or the other, but not both." Close quote. She would like to go to Mexico for health care, but is not legally permitted to cross the border on her temporary permit. Quote, "Being able to see a doctor has me worried sick, and I'm so afraid of the virus coming back. Last time it wasn't cancerous, but I'm afraid that if it does come back, it will be worse because I'm not having regular checkups." Powerful, no? Access is a problem because the ACA didn't go far enough to cover everyone. Access is a problem because states aren't doing their part to have their citizens have the insurance that they need and fund family planning clinics. And access is also a problem because those who have coverage are trying to keep their employees from accessing the contraception coverage benefit as well. I won't go into this because I'm sure we'll discuss it later, or you've heard about the Hobby Lobby case through other panels or through your classes. But I also want you to know that besides closely held corporations, there are religiously affiliated nonprofit organizations that are also trying their hardest to impose their religious beliefs on their employees and ensure that none of them have access to contraception. So I've been depressing and talking about nothing but problems. But in DC, we're trying to put forth a few solutions to the access problem. Last Congress, Senator Murray and Representative Slaughter introduced the Protect Women's Health from Corporate Interference Act. In DC, we call this the Boss's Bill. It's a federal response to the Hobby Lobby decision and acts to restore the contraception coverage benefit and protect other health services from employers who want to impose their beliefs on employees. The bill will stop bosses from being able to single out women's health for discriminatory purposes. As you may remember from the Hobby Lobby opinion, there was talk about how this type of discrimination would never be allowed for other types of communities, but it's okay because it's women's health. We've decided that this is such a good bill that we'd like to take it into the states, and we've been working with a few states. The National Women's Law Center has been working with a few states in order to get mini bosses bills introduced in the states, and DC, while not a state, is the first place to actually enact it. And a few months ago, they enacted the DC Reproductive Health Non-Discrimination Act, which doesn't allow employers to discriminate based on an employee's reproductive health choice. And unfortunately, this is under attack in Congress thanks to home rule. So that is one of the fights that we are gearing up for this Congress. And there's a segment of society that many people don't think about when it comes to contraception, and those are our military service women and their dependents. And they do not enjoy the same benefits as those of us who have private insurance thanks to the Affordable Care Act. So the Service Women and Dependents Contraception Bill, which was introduced last Congress and reintroduced this Congress by Senator Shaheen and Representative Speer, makes a range of FDA-approved contraception methods available at military treatment facilities, mandates that TRICARE, the military's insurance carrier, offer insurance coverage of all FDA-approved methods of contraception without cost sharing, which then makes them in parity with the ACA. It improves access to emergency contraception, helps provide confidential, comprehensive, medically accurate family planning counseling, and would create a uniform standard curriculum for family planning education programs. We may have come a long way since the days of Griswold, and thankfully so, but there are forces at work trying to turn back the clock and send us back to the 1960s, and we need your help to stop them. Thank you.
So I'm going to set Griswold at 50 in the context of a set of decisions in the sort of family law, reproductive rights, sex area, where many have noted a movement from sort of substantive due process grounds upon which these cases were decided toward an equality analysis of the subject. And Professor Siegel really emphasized the equality side of this, and I think it is the more modern way of thinking about reproductive issues, including contraception, but I just sort of wanted to retrieve a little of the original bases of these decisions. So both contraception in Griswold and Roe versus Wade right to abortion started with the Constitution, started and ended really with the constitutional right of privacy or autonomy, kind of stacked together with a few other First, Third, Fourth, and Ninth Amendment rights to create this kind of penumbra of autonomy rights that people would have toward this kind of decision-making. But over time, what we've seen, not only due to the scholarship of folks like the Professor Siegel and others, but also hints and analyses in various Supreme Court opinions, such as Justice Blackmun's concurring opinion in Planned Parenthood versus Casey, Justice Ginsburg's dissenting opinion in Gonzalez versus Carhart, and of course the various political debates about whether contraception should be included in the Affordable Care Act. This trend was all in the direction of viewing the problem as largely one, or in addition, one of women's equality. And I just want to quickly say that this is the same thing that's been happening in other areas. After Lawrence versus Texas, the movement towards same-sex marriage was really a privacy autonomy argument. We now think of it as marriage equality, but it started in the privacy autonomy realm. So just another exhibition of that. Sexual assault, we used to be thought of as it's all about protecting victims. We've got victims of a sort of phenomenon, and we need to protect them. And it's now largely thought of as crucial to women's equality. And same thing really with poverty more generally. Okay, so I'm making 3 points today. One is we see in the contraception area and in others this movement in scholarship and in judicial opinions from due process to equality. Second, it's not surprising that these issues would start in substantive, as a matter of substantive due process, not just because at the time of Griswold we didn't yet have heightened scrutiny in equal protection cases, but also because these cases don't tend to fit the more traditional formal equality framework. That is to say, even though the enforcement was uneven, Professor Siegel pointed out, the law itself prohibited contraception. It's not screaming men versus women, it's prohibiting contraception. And that's true all on down the line. To get this into equality analysis requires a very particular substantive view of the world. It's a view of the world in which women bear the burdens of childbearing and child rearing. It doesn't have to be that way, but it is. And it's because of the way the world is organized that this has become understood as an equality issue. Again, it's a very specific and contested view of whether or not that's the view of the world that we should be operating from. Okay. Finally, my third point is that both the substantive due process origins of these cases, including Griswold, and the equality theory that has evolved over time are absolutely essential in this area. It really doesn't work one alone. When we think about equality, it's important to notice, even under our substantive equality banner, all we're talking about is women getting the same as what men have. And of course, there's a long distance between the two, so a lot of work to be achieved to get to that goal. That may seem like a lot, and it is a lot. But there are rights that I think are arguably at stake now that aren't really about let's bring women up to the point that men are at, but that are more fundamentally challenging the right of the government to make these kinds of decisions for people. I don't know what the panelists think, but I think the Personhood Amendment is an example of this. It's being used as a way of cutting off right to contraception, but it's really a threat not just to women, but to the way we think about the world and the relationship between government and individuals. And I think we can't afford, in being attracted to the notion of equality, to give up that freestanding, independent, very much interrelated, but freestanding value that Griswold was founded in. So that part of it, I'm arguing, remains quite alive today, even as we incorporate more equality notions in our understanding of the issue.
Hi, everybody. I missed introductions. I'm Maxine Eichner from UNC. And I figured there were two other law professors on the panel, and so instead of talking about legal doctrine, I would spend my 10 minutes fantasizing. When you're young, you fantasize about particular things, and when you were a middle-aged law professor, you fantasize about reproductive justice and what a reproductive justice doctrine would look like that really reflects the reasons we think that reproductive justice is so important. We think decisions about being able to control your reproduction are fundamental to being able to choose your course in life, and that's part of what makes people human. So why am I fantasizing about this? The reason that most people fantasize, which is that the reality is profoundly dissatisfying. And I mean, there is no doubt that it was a huge accomplishment 50 years ago for the Supreme Court to find, in the Constitution, these protections for privacy. But as those protections have been enunciated by the courts, it's clear that that is a very thin and a very narrow set of protections. Mostly what they do is they keep the state from criminalizing birth control and abortion. They certainly don't ensure real access to women to birth control or abortion. We've seen in Texas that the state might be able to make women drive 5 hours or more to get abortions without interfering and unconstitutionally interfering with their abortion rights. We know that as the court has enunciated the doctrine, poor women have no right to access birth control. The Supreme Court stated early on in Harris versus McCrae, it simply does not follow that a woman's freedom of choice carries with it a constitutional entitlement to the financial resources to avail herself of the full range of protected choices. We know that the doctrine doesn't, or at least likely doesn't, prohibit women from suffering coercive and intrusive attacks to their autonomy when they try to access abortion. You know, we in North Carolina know this through the Women's Right to Know Act, in which the General Assembly passed a law requiring that physicians narrate to women ultrasounds, whether or not those women chose to hear them or not, including discussing the extremities of the fetus and what they appeared like. And when that was struck down in courts, the privacy doctrine was considered to be so weak it was struck down on the doctor's First Amendment, based on the doctor's First Amendment rights. We know that the state can pass measures that make it continually harder and continually more expensive for women to access contraceptions and abortions. We know that states can pass conscience clauses for pharmacists who don't have to distribute birth control. They can issue religious exemptions to employers who don't want to provide birth control. They can pass what are often called trap regulations, targeted regulations of abortion providers that require abortion providers, for example, to have privileges at hospitals, even though hospitals would be required to take emergency patients anyway. They can require the abortion facilities to have halls of particular widths that are the same widths of out-of-patient surgical centers, despite the fact that abortions the abortion procedure doesn't nearly raise a medical need for those things. So all these things they can do under the current doctrine of privacy, and so the question I'm fantasizing about is, what would a reproductive justice doctrine look like that really did protect women's reproductive autonomy, protected access, and protected their ability and knowledge to make those decisions? Let me say a few things about that, and I will not work through the Griswold doctrine except to say, you know, as you all read in con law, the court started out in privacy doctrine, and that privacy doctrine was formulated as a kind of keep-away doctrine, that the state had to not interfere with women. And at various points along the way, as both Kate and Neil were talking about, they have ventured slightly further into equality and autonomy terrain. You know, but even at its furthest in terms of autonomy, that autonomy has been framed in terms of the government just has to keep out of the woman's decision. So what would this more robust set of reproductive rights that protected women's autonomy look like? You know, it seems to me as it would do two things. You know, the first, it would ensure that women had the education and the capacity to make those decisions for themselves. You know, what would this mean? This would mean sex education in classrooms, and it would mean sex education in classrooms that taught about birth control, that taught about reproductive systems and how to plan and prevent births. And it would mean that parents couldn't take their kids out of classrooms just because the parent decided that the child shouldn't have that knowledge. What do we have now? Largely we have abstinence education in schools. The Bush administration funneled billions of dollars into abstinence education. Where there is contraceptive education, it tends to be slim to minimum, to slim to none. About 1 in 4 adolescents between 15 and 19 received abstinence education without receiving any instruction about birth control at all. Among teens aged 18 to 19, so these are kids who are certainly approaching, well, let's say well within their reproductive years. 41% that reported that they knew little or nothing about condoms, and 75% said they knew little or nothing about birth control pills. So one thing we'd do is we'd make sure that young people had the wherewithal to actually exercise reproductive autonomy. And another thing that we would do is we would ensure that reproductive autonomy actually exists out there in the world, so that that people can take those choices and actually make those choices in real life. What would this mean for the role of the state? It would mean that it would be the state's job to ensure affordable birth control and abortions that women could actually afford. And if women couldn't afford that, it would mean that the state would be required to subsidize. It would mean that the state couldn't legitimately heap on regulations, many supposedly geared to women's health, that make abortions and birth control more expensive and more difficult to access. And it means that the state would have to respect the autonomy of women who sought to make these choices. Boy, what would that mean? Certainly it would mean that the Orwellian women's right to know would go down in flames. The state shouldn't have the right to coerce women to receiving information that they didn't want to receive in that context. That doesn't mean that the state couldn't push its goal of birth if that's what it chose to push, but the way that it pushed it would have to be, for example, making birth a more appealing option for these women by, for example, agreeing to subsidize children to some extent and agreeing to provide pregnancy leaves and other measures which would mean that women could have birth without the really difficult consequences for their lives that they have today. I will leave that there. Thank you.
I like that fantasy.
So we have like 10 to 15-ish minutes left, so I'm at this point kind of going to open it up to you guys, questions for the panelists.
So I wanted to fantasize a little bit too and talk about what can be done about the Hyde Amendment and if there's any sort of legal way to get around the Hyde Amendment or any attack that can be made on the Hyde Amendment, because restrictions on Medicaid, as you said, Medicaid is such a huge source of care for women who really need reproductive health services and don't have access to it, and it seems like the Hyde Amendment is one of the biggest obstructions to that. So is there anything that can be done?
Legally, it's really tough. Once it's in, it's kind of in. DC is really lazy. People love to just do a copy and paste job from previous budgets. So once it's in one, it's really hard to get it out. But of course, the reproductive rights community has been fighting very hard to eliminate Hyde. So there's a great coalition, the All Above All Coalition, that has been collecting stories and explaining how hurtful this restriction is. and explaining how detrimental it could be when women cannot afford to get the abortion care that they need. So really right now it's about stories, it's about discussing the impact and trying to get legislators to talk about it in a more values-based way, so that we can get people to understand that this is an important piece of healthcare that a lot of women can't access.
So I do think that this is one area where the political appeal of the equality notion is going to be a lot stronger than autonomy, which has been understood more as keeping government out than having government be assistant. But we are talking about legislative solutions, and these can happen at the federal level, but they can also happen at the state level. It used to be, not that long ago in North Carolina, subsidies for abortion were for abortion or contraception now, I can't remember.
Abortion
Were quite significant, and now they aren't. So, you know, it's a question of political power within all the levels of government.
So in California, abortion care is subsidized by the state. Oregon just recently introduced a wonderful abortion care omnibus bill that will also provide a lot of subsidies for abortion care.
It's also the only state that hasn't imposed further restrictions than the court had in Roe v. Wade.
It would take a very different court and a very different jurisprudence, right? Because even when the court protected abortion under strict scrutiny, under Roe, they said, as Professor Eichner commented, there's still no entitlement to funding. I mean, there is doctrine available that could be leveraged, right? I mean, you could talk about unconstitutional conditions on the exercise of the right. If the woman possesses the right and the state is funding one choice and not the other, right? Is that an unconstitutional condition on the exercise of the right? It's just no court has been willing to go there.
So I was in Texas when they were passing the legislation that really cut down on the amount of clinics and the access that women had. And I was about an hour away from Austin, and it was really hard to find information about that as it was happening. Like, I remember I was looking for it on the news, and CNN was reporting on, like, blueberry muffins was the thing they were talking about. So I'm wondering if you think that what's being traditionally thought of as, like, women's issues, do you think that's going to be more represented in the news? Do you think that will help? Do you think that's something that's coming soon, or?
I hope so. I think if a certain candidate decides to run for president, you may see more women's issues come up on the national stage. I think also the fact that so many states now are passing so many different types of regulations, which were discussed earlier, and the impact has been to shut down so many clinics. Hopefully that will reach the national ether a bit more. And 2 states, North Carolina being one of them, Mississippi being the other, and Texas may soon make it 3, have petitioned the Supreme Court for cert on losses that they've sustained when it comes to some of their abortion regulations. So North Carolina petitioned the Supreme Court to review the ultrasound loss, and Mississippi has asked for review for their loss on their admitting privileges requirement, which is responsible for shutting down so many clinics in Texas, almost half. So we should be seeing more of these issues come to light and talked about in the press. And hopefully a lot of stories and a lot of impact stories will make it out there.
I think this will take more advocacy, not to turn it back to you, but from your generation. This is I think often viewed as a sort of middle class. These were the accomplishments that were achieved from what are now an older group of women who feel like the younger ones don't really appreciate it. And there's not a lot of noise coming from those, from the 20-somethings and 30-somethings. And, you know, without that, where will the political energy come from? So
the court came very, very close to overruling Roe in '92. Justice Kennedy had already voted in 1989 to overrule Roe. Chief Justice Rehnquist had already written the opinion in Planned Parenthood against Casey, which didn't say we're overruling Roe, it just said rational basis review. And Justice Stevens said within the court, if you're going to do the deed, then say what you're doing. Don't just throw Roe out of a fast-moving caboose. And so I don't know how many Americans, relatively young Americans, understand how close the court came in '92. And one thing we know from history is that constitutional law is intensely historically contingent. Anthony Kennedy is not going to be deciding what undue burden means or whether undue burden is the test forever, right? Elections are going to have enormous consequences. Not realizing Professor Eichner's fantasy, but certainly with a lot of these laws that are in place and being put in place, a lot of them are going to easily flunk any relatively sympathetic understanding of undue burden that I thought the court had applied, the original meaning of Casey, if you will, right? I think you've seen a real change over time in what that means, and it can change yet again. And so a huge difference in constitutional law is the difference of one vote. Or to put it differently, if John Kerry wins the 2004 election, and he almost did, I teach a very, very different first-year constitutional law course, including in the area of abortion rights.
So thinking about the backlash, I think we've seen maybe different responses in the judiciary versus in the legislatures. In the judiciary, it's more like, well, maybe privacy is not a right at all. It's not in the original text in any way, or lowering the level of scrutiny, whereas the legislatures at state and federal level have been much more paternalistic, I guess emphasizing the Latin root of that word, and saying like, well, you know, if you're going to have an abortion, it should be in this nice hospital where it's safe, you know, or you have a right to know about these things. And so I'm wondering, that those seem like very different responses. And I'm wondering if you think the legislatures are getting a cue from the courts at all, and if so, where would they be getting that? Because it just seems kind of fundamentally different to me.
I would be happy to answer that. I think it's part of the same. You should see the legislature as responding to the courts, beginning in Webster and following in Casey. It became clear that the court, although not overruling Roe on its face, was, and this has been said in a number of dissents from the liberal justices, you know, through winks and nods, inviting states to roll back Wade. I think in the pro-life community, there was originally a real battle about whether to try to take halfway measures that rolled back Wade or Roe versus Wade, or just insist on getting rid of Roe altogether. And that battle has clearly and decisively, I think based on signals from the Supreme Court, been won by the folks that say we can go great ways toward altogether eliminating access to abortion without criminalizing it on its face.
So Professor Siegel and Professor Bartlett, you both talked a little bit about the same-sex marriage equality movement. I know that in class we've discussed how the same-sex marriage equality movement has learned from both the from the sex equality movement. And I guess what I want to ask is, how do you think the access to reproductive justice movement can learn from the same-sex marriage movement now in the way it has succeeded, both within litigation, but also in the political and popular spheres?
Well, I think what the court is, I could tell you in the litigation or jurisprudential context, I mean, is the court formalist? Is the court talking about an anti-classification conception of equality in Windsor and Lawrence? It's talking the way Charles Black used to talk about the Equal Protection Clause in defending Brown. It's Justice Kennedy in Windsor is talking about the purpose, effect, and dominant social meaning of Section 3 of DOMA, which is demeaning the dignity and reinforcing the inequality of individuals and couples who are perfectly well positioned to participate in the institution of marriage. It's much more of a robust, substantive understanding of equality. And so, you know, if the court can do that, if Justice Kennedy can do that in the context of gay rights, and including reasoning based on equal protection principles, not just based on substantive due process, well then, maybe it's not just sheer fantasy to think about the Equal Protection Clause bearing both legal and political authority in the future in the area of reproductive rights. This more robust substantive understanding of equality is something Justice Kennedy is already doing in a different area of law.
So that's the fantasy. So I think marriage is so much easier to understand as a fundamental right than contraception and abortion. But I think one may have learned from the other, but it's really just sort of gone, kind of lapped it at this point and is off on its own, expecting victory any day. And, I don't know how much we'll learn from that can be used back in the trenches of this issue where we seem to be going in the opposite direction.
Okay, Kate, I'm not going to let this session end that way. I think that there's lots to be learned, and I think the fact that you all are sitting in the room and the fact that I showed up from UNC to give a 10-minute talk, all of those are lessons. I mean, what got learned in the marriage campaign is that organizing matters. I mean, the litigation that happens in the courts matter, but the LGBT groups were working on the ground, and they were working hard, both before and after those court opinions to, have those 10,000 conversations that they had, and that made a difference on the ground. I think there are many criticisms of Roe that are inaccurate, but the extent to which the folks who considered reproductive justice important stopped trying to organize politically and started to solely depend on courts was a huge problem, and we're experiencing the benefits these days. There are so many folks who are not aware of how important these issues are, and my kids did a family history paper for high school a few years back, and in talking to both my parents, it turns out there was a great-grandmother on either side of the family who died after having kids from an illegal abortion. We don't talk about that, and we don't talk about how important these issues are, and when we do, we tend to talk about them through courts rather than organizing, and that's something I think we can really learn from the marriage movement.
I can't emphasize that enough, how powerful storytelling can be, because when the LGBT community started coming out of the closet, women started going in them. After Roe was decided, they felt they didn't need to tell their stories anymore. They didn't need to tell their illegal abortion stories or their abortion stories anymore. How hard is it it's very hard to deny someone the right to marry if they're your cousin. Your cousin has come out to you. You can't look them in the eye and say, well, there's no way you deserve the same rights as me. So more women need to come out of the closet and tell their abortion stories and normalize it. It's 1/3 of women will have an abortion in their lifetime. It's a very common, very safe procedure, and the more we talk about it, the more we normalize it. I think it will end up becoming a movement much like the LGBT communities.
1995, I just graduated from college at Duke University, and it is sheer fantasy to think that one day the U.S. Supreme Court will declare a nationwide right to same-sex marriage. Never going to happen.
There you go.
All right, let's give a hand to our speakers.
Do you have 5 minutes?